John Cogswell, Davis, Colorado. Before I arrived yesterday, there had been communications between Don Reimer and the auctioneer and his representatives. When they learned that it would take 6 months to do a subdivision, they started talking about boundary line adjustments, which depended upon how many tax parcels there were. That's where the 8 or 9 arose, because then there would be these lines, and could these lines be readjusted to make it more marketable? When the auctioneer told me all the troubles they were having, that this would take 2 or 3 weeks and so forth, I said, I think we're exempt. And I then filed this. So there's a two-pronged situation going here. One, for a boundary line adjustment as a fallback remedy for at least 9 lots that seem to be marketable. Or, but the Jenny correctly stated, the issue. She and I disagree. And I want to address that since I won't be allowed into executive session, I presume. But let me say this, that there is nothing in the state law that prevents us from filing a plat right now with 18 parcels and selling those 18 parcels. Except the county might sue us after we do it and say they weren't exempt. We're going to, because it says here, unless the method is adopted for the purpose of evading this part, the term subdivision and subdivided land as defined shall not apply to any division of land, and I'm relying on the deed of trust exception. Now, there's nothing in here that says as determined by the county commissioners. Anybody can read the law. It says it's exempt. So we just file a plat. But in this day and age, with the government lingering around everywhere, there's always the question mark that the buyer's going to ask, well, how do you know that the county won't sue us or try to upend this sale? That's why we're here, to get certainty. This whole country's living under an atmosphere of uncertainty because nobody knows what the law is anymore. That's why we're not here on an application where we have evidence and hearing, like I mentioned yesterday. We're here to decide what the law is. And in my opinion, we're exempt. And I would like the county commissioners to say that if we de-annex from the town, you agree that we are exempt based upon the mortgage deed of trust exception. Now, just a few comments on that. Jurisdiction. Yesterday I said, equity regards as done that which ought to have been done. This is an axiom first set forth by the United States Supreme Court in 1887 maybe. In Walker versus Brown, it's been confirmed by the Colorado Supreme Court in Hall versus Burrell, a 1912 case. And it basically says, since the right thing to do here could put us in the county, we have a nexus, which is another standard of jurisdiction, both personal and subject matter jurisdiction. We have enough connection to this county that you can make this declaratory ruling that we're requesting. We are in the county. We're also in the town. And we have a right to get out of the town and be solely within the county. And we're citizens of the county. And so there is a connection here. The same way the United States, for example, the IRS taxes somebody who earns money in France. Hey, they pay taxes in the United States because there's a connection. That person's a citizen. Blackmer versus the United States. Okay. So I think there is jurisdiction for you at the request of a citizen to say whether you agree or disagree with us, so we would have some certainty. Now when it comes to the exemption, I want to repeat again, the general rule in Colorado is that people are free to do with their property what they think they should be able to do with their property. And that is the overreaching general rule. Second, that general rule has a regulatory provision when they have a subdivision law that says, well, you can only use your property, but you got to do A, B, and C and divide it in this way and so forth and so on. Those laws are strictly construed, meaning if there's any doubt about whether there's a restriction, you resolve it in favor of the landowner, not the government. And when that law of restriction, namely subdivision regulations, contains an exemption, which is what I'm dealing with here, the law is equally and forever said exemptions are liberally construed, meaning if there's an exemption, you bend over backwards to help the landowner, not the government. The intent is to get back to that general rule that we're free people. Now, your attorney will tell you those are the rules. These rules are undisputed. Now, the only issue is what does the exemption mean? The exemption says this, in a nutshell, that unless the method of disposition is adopted for the purpose of evading these rules, which is one issue, and I argued yesterday that that didn't apply because, I mean, this mortgage has been in effect for a long time, shall not apply to any division of land which is created by deed of trust. Let's just use that because that's what we have in this case. Shall not apply to any division which is created by deed of trust. Now, a deed of trust does not divide land. A mortgage does not divide land. Security interests don't divide land. Liens don't divide land. They're a way of saying that a lender has a right in that property. In Colorado, for example, a holder of a deed of trust with installment note can foreclose on parts of the land without foreclosing on all of the land. So, why did they write this, and what does it mean? It has to mean that the lender's rights under the deed of trust would be acknowledged. And if the lender believes that its security interests can best be realized, and it has the greatest opportunity to recover the monies due it by selling it in parcels at an auction, through the bankruptcy court, or coming to the public trustee and coming up with some novel theory, to me, that is what it refers to. It is a policy that preserves creditors over the benefits the public may have in dividing land according to rules and regulations. Now, you can say, again, look at it. If you're confused about it, it's an exemption. You resolve it in favor of the landowner. You resolve it in favor of no of the exemption. That's why I mentioned the law on exemptions. And if there's any confusion about the general rule up here, that it's exempt, it's all resolved in favor of the landowner. And to top it all off, that's the general law in Colorado to begin with. Now, believe me, this lender just wants to be paid. I mean, any way to get him paid. And when they sign on and help negotiate, which happened here, and that would be the evidence at a trial. As a matter of fact, they pretty much wrote the auction agreement. And they trust this auctioneer to do it this way to get their money. That is action by them under their deed of trust. And the word deed of trust, as used in that exemption, has to be given a full meaning, not just an instrument. You know, you don't just say deed of trust and sign your name with a piece of property attached. That doesn't tell you anything. It has to say what your rights are, and you've seen these deeds of trust. They go on for pages and pages and pages. That's what it refers to. It refers to everything that can be in a deed of trust and all the discretions that a lender has in his deed of trust. And here, the lender has decided this is the way to go. It's a bankruptcy order. And if you give this the proper interpretation under Colorado law, you will find that the exemption applies. I want to just say one other thing. There's no technical rules that apply in the construction of statutes. Colorado has a whole series of statutes that tell you how to construct the statutes. For example, common usage, when you look at a term, not technical usage. You interpret them to generate a just and reasonable result. 2-4-201. If there's an ambiguity, you resolve it in favor of the object to be obtained. Here, to pay the creditors. Words are to be given a liberal construction to carry out the meaning of the legislature. So this is all overlays everything. I think when you apply these statutory rules of construction, the case law rules about exemptions, recognizing this is a free country, and that freedom is the essence here, and it should be preserved, and that's the way the Supreme Court has ruled. You have to agree that if we file a plat that has 18 parcels, that plat is exempt under the state statute. And we would like to know that the commissioners agree with us so that if we do this, we don't have a lawsuit afterwards. That's why we're here. Any questions?
Not right now, John. Thanks.
Thanks, John.
And again, it's important, as soon as possible.
I see that Buena Vista is now here. Do you have comments, Sue?
Sue Boyd, Town Administrator, Buena Vista, 6161 Avenue, Buena Vista. Just briefly, I'm sorry I missed the comments so far, but from the town's perspective at this point, the medical property continues, as of today anyway, to be an annexed property within the town limits of Buena Vista. We do understand that the owner, Mr. Cogswell, may desire to de-annex. Our attorney is the one who really should speak to the specifics of that, but in general, a petition to de-annex from the town needs to be submitted. I think the town, according to statute as well as according to the annexation and development agreement that's in place, would need to hold a public hearing, approve an ordinance de-annexing the property. I think the town is prepared to do that if we do indeed get a petition filed, but at this point, none has been filed so far. Otherwise, for the moment, the town considers the property annexed and subject to the town subdivision regulations, and also subject to the existing annexation and development agreement that was approved in conjunction with the annexation.